And so, we've talked about Illinois already, which is, for those who haven't listened to Diane's first and second previous episodes, is based in Illinois. And we talked about the last time we talked, PetMeds was still, we hadn't gotten a decision out of PetMeds.
Mhm.
Um, and so do you want to maybe talk us through or catch us up on, the results of PetMeds, what the legislator did as a result of that, and how that's kind of impacting taxpayers and, you know, maybe we need to bemoan some things, maybe not, but kind of catch us up on kind of what happened with Illinois and the leveling the playing field and what's come out of that.
Sure. So to take you all the way back, Illinois, prior to 2021, um, their tax structure is a sales tax, which we call the retailer's occupation tax, which is an origin based tax for transactions that occur within the state of Illinois. And the tax rate is dependent upon where the seller is located. For sales that originate outside of Illinois or where inventory comes from outside of Illinois, that is subject not to the retailer's occupation tax or sales tax, but to the use tax. And the use tax has no local tax. It is only the 6.25% rate. So, for any sellers, remote sellers, or even sellers with physical presence in Illinois, but maybe the inventory and the order acceptance and everything came from outside of Illinois, they would only have a requirement to collect tax at the 6.25% rate. Now, there's a long, sordid history of how you determine what is the origin of the transaction. With the leading case back now, gosh, I've lost track of what year it was. The uh, Hartney oil case. I think that's the right name. Hartney oil. And so that defined an 11 prong test that we go through to determine what is the sourcing. Okay. And so that was in place. 2018 comes, Illinois enacts economic nexus, and most of these sellers are located outside of Illinois. So the only rate that is being charged is the 6.25% state rate. And all of the locals are up in arms screaming, "Where's our Wayfair money? Where's our Wayfair money? We're not getting any of this money." And so the legislature went in and passed a law that said effective 2020. Why am I drawing a blank? 2020, 2021. That now remote sellers are not subject to the use tax, but they are subject to the retailer's occupation tax. And that meant that all of these remote sellers were required to charge state and local rate at the destination. So that remote seller, let's say it's you guys, you're located in Colorado, you're a retailer, you're selling to me in Chicago. The Chicago rate is 10.25%. But the use tax rate was just 6.25. So you were charging me 6.25% rate. This law went into effect. You now had to charge me 10.25% rate. Um, and so the argument that was made, because Illinois is an origin state, is I could buy from a vendor in another city in Illinois at a rate lower than 10.25%. And now this out of state merchant is disadvantaged and is required to charge a higher rate than what an in state vendor. And so for a constitutional uh, challenge to this is what happened with PetMeds was the first one that did that. There's been a number of other cases that are in the works right now that made the argument that this was a unconstitutional law change because it did put a higher burden on out of state sellers than on in state sellers. We have a prior case from Missouri, the Associated Industry case from the late 90s, that went to the Supreme Court that said you can't have a higher rate imposed on out of state sellers than in state sellers. So that was the argument that PetMeds made along with these other cases. We were hopeful that we were going to get a decision on this. The PetMeds case ended up settling. So we don't have a decision on that yet. There are still some other cases in there. But what happened in January of 25, Illinois changed the law once again that said now all out of state sales, whether the seller has physical nexus in Illinois or not, if they were only required to collect six and a quarter under our crazy 11 prong test, they now have to collect tax at destination sales tax. And so I think Illinois thought that this change would make their constitutional challenges go away. But all it did was it made more businesses now subject to this unconstitutional challenge and discrimination really is what it is, because still if I buy from an in-state seller that has a lower rate than this out-of-state seller, I as an out-of-state seller am discriminated against. So it'll be interesting to see what happens. This bill that I talked about to eliminate the 200 transaction count, it has included language that I think is very onerous that says if the seller does not provide all of the documentation of where all the sales went, the department, instead of asking the seller to perfect their return. So in essence, if they submit an unprocessable return, which would probably mean they didn't attach their local schedule, the ST2,
Mhm.
instead of waiting for the taxpayer to submit that to perfect the return, the department has the right to just assess a tax of 15%, which is higher than any other tax rate that exists in the state. So I think they just keep piling more and more discriminatory provisions into their statute. And I'm hoping to God we get a case that actually gets to the courts.